Moving right along, the term law in Section 15 should be given a liberal interpretation encompassing both legislative activities and policies and practices, even if adopted consensually. So private policies or governmental policies or practices that aren't law but are accepted consensually. So this statement is much like common law, which was not always written down but accepted by society as law. If we think do no harm, not all forms of harm were written down, but it was accepted as if you do harm, you will be held accountable by a jury of your peers. And there was different degrees of harm, yes, of course. For example, not everywhere, not every place in North America, for example, wrote down if you steal someone's horse, you can be hung. But it was accepted as law. Moving right along. So the Oakes standard presumptively applies, and only in exceptional circumstances should the full rigors of Oakes be ameliorated. So there's an Oakes standard in the Oakes case, which we will be reviewing in a separate video. Excuse me. The Oakes test, to give you a basic, is it demands that government infringes as little as possible and their measures are reasonable and for taking away rights and freedoms and so on and so forth. But we'll cover it in a different video. It is doubtful whether citizens should be able to contract out of equality rights, having regard to the nature of the grounds on which discrimination is prohibited in Section 15. So they're saying a citizen, a person, shouldn't be able to contract out of your rights, which is exactly right, especially if that contract is based on deliberate deception, fraud, and tort. We have not forsaken our inherent rights and duty to do no harm, or we have forsaken our inherent rights and duty to do no harm for granted rights and impose duties through the contract, birth certificate, application and registration, social insurance number, application and use, driver's license, application, registration, and use. So we've given up our inherent rights and our duty to do no harm through volunteering to contract. Are men and women not discriminated against in a legal system and jurisdiction that only recognizes artificial person and corporations? Is that not discrimination against men and women, against human beings? I would certainly argue it is, especially because we know the mandatory birth registration, and we're told mandatory application and acceptance of the birth certificate, the social insurance number, the driver's license, the fishing license, contracts, all based on deliberate deception and fraud. And no contract in law can stand if it's based on deliberate deception and fraud. And they're saying it's doubtful whether you should even be able to contract out of your rights, which you can't. You can't give them away. They can be taken away by force, or you can choose of your own free will not to use them, even if that's through a deliberate deception and fraud. Section 24.1 of the Charter confers a broad discretion upon the court to award appropriate and just relief. Yes, it does. And herein lies one of the problems. Once again, ladies and gentlemen, judges are appointed by governments. They're appointed by the system for the system. Are there some good judges out there? Yes, and I'm sure they're trapped within a corrupt system. But if you really look at it, if you follow their Acts, Statutes, Regulations, Codes, all the way back to the BNA 1867, it's wrought with deliberate deception and fraud. And it's a breach of contract. The trespass committed against us is a secondary issue. That's an issue of harm or tort. That's separate. First, we have to prove the breach of contract. Then, once that is proven, the tort, the harm, is easily proven. The trespass. Once again, Wilson J's broad test for determining the scope of government and government action for the purpose of Section 32.1 of the Charter was agreed with. Those three questions was agreed with. And moving right along, the application of the Charter. We know what the Charter reads. It applies to the Parliament and Government of Canada and the Legislature and Government of the provinces. These words give a strong message that the Charter is confined to government action. This court has repeatedly drawn attention to the fact that the Charter is essentially an instrument for checking the powers of government over the individual. Once again, that's what they believe, and that's what they will have us believe. But I ask you, was the Charter and the Constitution Act 1867 created by the people, for the people, ratified by the people, or was it created by government, for government, in fact, UK government, on behalf of the Crown, to control the people of Canada? I ask that simple question. It is intended to constrain governmental action inconsistent with those rights and freedoms. It is not in itself an authorization for governmental action. And continuing on, so this is, which is this? Oh, in Operation Dismantle Inc. versus the Queen, which we will be reviewing at page 490. Wilson J. noted that the central concern of Section 7 of the Charter, Section 7 is legal rights, is direct impingement by government upon the life, liberty, and personal security of individual citizens. Emphasis added. See also R. Regina versus Big Drug Mart, which I referred to earlier, which we will be reviewing also. And the Dolphin Delivery case as well. And the Dell case as well. The exclusion of private activity from the Charter was not result of happenstance. It was a deliberate choice which must be respected. We do not really know why this approach was taken, but several reasons suggest themselves. And it goes on and on and on, but we know why the charter was created in the first place: to perpetuate the illusion of freedom in a system of control. And once again, that's just what I've said in my notes. However, thanks to Walter Kuhl in 1974, by exposing the fact that after December 11th, 1931, the government was de facto, he exposed that to René Lévesque in a very famous letter. He provided René Lévesque with all of that information. When René Lévesque wanted to have a referendum in order to decide whether to for Quebec to separate from Canada. And in Walter Kuhl's famous letter, he says, René, you can't have a divorce without first being married. Quebec and every province is a sovereign nation as of December 11th, 1931, after the passing of the Statute of Westminster. Okay, I digress back to this case law. The leading authority in this area, of course, is court's decision in the Dolphin Delivery case, Supra, which sets forth many other considerations. Once again, we will be reviewing the Dolphin Delivery case. It's very interesting. Section 32, it refers not to government in its generic sense, meaning the whole of the government apparatus of the state, but to a branch of government, emphasis added. So far as a legislature was concerned, he stated, it was only by way of legislation that it could infringe the charter. Action by the executive and administrative branches of the government would not generally depend on the legislation, but there were also situations which do not concern us here, where it would depend on common law rules or the prerogative. Here we are, ladies and gentlemen. So for all of you people out there that have been told that the common law is a myth and all of that stuff, I'm here to tell you it's not. And it's mentioned briefly in this Supreme Court of Canada appeal case, but it's mentioned in many other cases, as well as natural person or private person, meaning the man or woman, the human being. That is why I teach people the difference. I show them through legal dictionaries. This is a natural person, sometimes referred to as a private person in law. This is an artificial person. McIntyre J. thus carefully limited the Charter's application to Parliament and the legislatures and the executive and administrative branches of government. It is significant, too, that in buttressing his view as to the meaning of government, he relied not only on its general meaning, but also on the manner in which the words were used in the Constitution Act 1867. Once again, they take the Constitution Act 1867 as law. So whether we know personally, which many of us do, that it's not law, that it is corporate law, it is legal, it's not law. Anyhow, moving on. The appellants first argued that universities constitute part of the legislature or government of the province within the meaning of Section 32 of the Charter, insofar as they are creatures of statute, which exercise powers pursuant to statute and carry out a public function pursuant to statutory authority. Sounds familiar, doesn't it? Like the artificial person, the agent of the government, acting under the social insurance number, exercising, which is a creature of statute. The government created the artificial person. The government created the social insurance number, which exercise powers pursuant to statute. We're granted the right to work under the social insurance number, and that is definitely considered a public function, because to government, there's no higher function of the people than paying their taxes. That's the highest function. Without our taxes, they couldn't exist. The close nexus between the statute and the legislative scheme and governmental administration is immediately obvious. The mere fact that an entity is a creature of statute and has been given the legal attributes of a natural person is in no way sufficient to make its actions subject to the Charter. Such an entity may be established to facilitate the performance of tasks that those seeking incorporation wish to undertake and to control, not to facilitate the performance of tasks assigned to government. And once again, this is true with private corporations. They're incorporated by the government, but they're not necessarily part of government. We've seen some of the tests they apply to figure out if they're part of the government. But the creation of the artificial person or the corporation with our names, that is to bring us into their jurisdiction. Then we voluntarily apply, use their identification, our artificial person, to apply for a social insurance number. And once again, it is presumed that when we apply and register, we know exactly what we're applying and registering for and what that means. It's presumed. I'm sure there's a maximum of law, but I don't know off the top of my head right now what it is. And again, natural person is mentioned. Common law is mentioned within judges' opinions, decisions, and case law, all the way up to the Supreme Court. The British Columbia Court of Appeal refused to apply the Charter to a collective agreement, though such agreements are provided for by statute. Excuse me. They were unenforceable at common law, and the legal status of the union itself derived from statute. The BNA 1867 was forced upon the people of Canada. It was a statute created by the UK Parliament. In fact, over 30,000 people in Nova Scotia voted against the BNA. And despite the fact that that was more than 50% of the population, the voting population, who were men at the time, but more than 50% of the population in Nova Scotia said no. And they were forced into the BNA. Does that sound like confederation to you? Does that sound like a constitution to you? If one of the 4 provinces voted against joining and were forced into it. Moving right along. There is perhaps a faint argument that the Charter applies to the actions of all Canadian corporations, whether publicly or privately owned, and even if they are engaged only in commercial activity. Aha! The argument would start from the premise that the existence and powers of a modern corporation depend on the statute which authorized its incorporation. In that sense, it could be argued all modern corporations act under the statutory authority and should be bound by the Charter and all other acts, statutes, regulations, codes, bylaws, rules of the court, and rules of civil procedure. Excuse me. But the better view is that a corporation, once it has been brought into existence and empowered, admittedly under statutory authority, it is thereafter exercising the same proprietary and contractual powers as are available to any private person. Once again, private person, natural person are both used in Acts, Statutes, Regulations, and Code and recognized by the courts. You just have to know who you are and stick with it. People of Canada are not acting in our capacity of a man or a woman, a natural person, a private person. We are acting as our artificial person or our corporation, created through the birth registration and application for the birth certificate. And then we apply for the social insurance number. And once again, when we apply for something, it's presumed that we know exactly what we're applying for. The situation just described is entirely different from requiring a person to do something, and it is different also from empowering someone within the government apparatus to do something. A public purpose test is simply inadequate. It is fraught with difficulty and uncertainty. It is simply not the test mandated by Section 32. We're just touching on, for the sake of time on this video, we're just blasting through interesting parts. I encourage all of you to read this entire case law yourself. As per Justice Callahan, I hasten to add that I agree with my colleague, Justice Wilson, that the Charter is not limited to entities which discharge functions that are inherently governmental in nature. As to what other entities may be subject to the Charter, by virtue of the functions they perform, I would think that more would have to be shown than that they engaged in activities or provision of services that are subject to legislative jurisdiction of either the federal or provincial government. So there you go, ladies and gentlemen, the provision of services. What is the Government of Canada? It is the Crown Service Corporation of Canada. I therefore conclude that the respondent universities do not form part of the government apparatus, so their actions as much do not fall within the ambit of the charter. Again, this has been argued all the way through the courts, so there's been agreements and dissenting opinions, and we're just touching on parts. With difference to my colleague, Justice Wilson, I do not rest this conclusion on a belief that the role of government should be strictly confined. I would note that it seems to me that if one were indeed committed to the doctrine of constitutionalism, as my colleague describes it at page 342, one would interpret government for the purpose of Section 32 as broadly as possible and not in its narrowest sense. Once again, judges have a lot of discretion. Yes, they rely on other opinions and other decisions and precedents and case law, but they have a lot of discretion to interpret Acts statutes as they seem fit. And they are appointed by the government. And they support, even though they may know that the BNA was never a constitution, that Canada never confederated, that the government is de facto. They're still part of the system and they're appointed. And some may bite the hand that feeds them, but some may not. So how do you know? Yeah, some judges historically rule on the side of the Constitution, which is great. But once again, it's all fraud. So more opinion. Here again, however, I am unwilling to accept that a power by government to contract should include the power to contract in violation of a charter right. Wow! Here we have another a justice of the Supreme Court of Canada's opinion saying, here again, I'm unwilling to accept that a power by government to contract should include the power to contract in violation of a charter right. How about an inherent right? We're through deliberate deception, fraud, and eventual tort and trespass, we're deceived into foregoing our inherent rights and God-given duty to do no harm, to granted rights and impose duties under a contract. And this judge is saying, I don't think the government has power to contract where it's going to take away a right. It would be easy for legislatures and governments to evade restrictions of the Charter by simply voting money for the promotion of certain schemes. There's that word again, schemes. They use it quite often. Schemes. In Operation Dismantle Inc. versus the Queen, Supra, at page 459, Justice Dixon drew attention to the possibility, that if the supremacy of the Constitution expressed in 52 is to be meaningful, then all acts taken pursuant to the powers granted by law fall within Section 52. And there you have it, ladies and gentlemen. A Supreme Court Justice. We will be reviewing this case, agreeing that if 52 is to be meaningful and taken seriously, then every other act, statute, regulation, code, bylaw, rule of court, rule of civil procedure fall under Section 52 and if they are inconsistent with Section 52 or any other provision of the Charter and Constitution, they are of no force or effect. And we're seeing through their own tests that the Charter applies to only government. We are acting unbeknownst to us through our artificial person as an agent of the government when we are implementing their Acts Statutes, regulations, codes, bylaws, rules of court, rules of civil procedure, when we're using our government ID, when we're applying for a license to catch a fish or to marry the person that we love. There you have it, ladies and gentlemen. Not my words, Supreme Court of Canada. And once again, I'll say we are going to show this over and over through case law. I just chose this one first because it's fantastic and I found it hilarious that it deals with retirement age and forced retirement. Yeah, we're not forced to retire by the government, but retirement age is 65 and then we get our employer's pension. There is no doubt that policies, agreements, and regulations impose burdens on the employees. More case law to review. Work is one of the most fundamental aspects in a person's life. Providing the individual with the means of financial support and, as importantly, a contributory role in society. A person's employment is an essential component of his or her sense of identity, self-worth, and emotional well-being. That part may be true. And we are contributing to society through working, but we are also implementing government policy and forwarding the illusion of public interest by government. Let's see. I put all these footnotes in an attempt not to go off on ranting tangents. Let me know if you think it worked. We are forced to register for a birth certificate and social insurance number, once again through deliberate deception and fraud. Men and women, our artificial person, must have a social insurance number to legally work in Canada. Does a permit, a granted right to work, does that sound right to you? Were we not born free men and women and we can work if we want to support ourselves? Is that not an inherent right? Not when you voluntarily act under the artificial person and the social insurance number. The second argument that was similarly situated test is still the governing test, provided it is not applied mechanically. Simply put, I do not believe that the similarly situated test can be applied other than mechanically. And I do not believe it survived the Andrews versus Law Society of British Columbia, which we may or may not review that case as well. I'm just trying to show you what they're talking about, but also give you an idea of how these judges think and act. The onus of justifying a limitation to a charter right rests on the parties seeking to uphold that limitation. And that is part of the Oakes test, which will we'll probably review that case next. But it's also part of the recent Rocco Galati test. He's using the Oakes standard in his case filings. The starting point of the inquiry is an assessment of the objectives of the law to determine whether they are sufficiently important to warrant the limitation of the constitutional right. The challenged law is then subjected to a proportionality test, in which the objective of the impugned law is balanced against the nature of the right, the extent of its infringement, and the degree to which the limitation furthers other rights or policies of importance in a free and democratic society. So again, that's they're referring to the Oakes standard, which we'll cover in another video. And part of Rocco Galati's case involves the Oakes standard, making the government prove, which of course we know they can't through science, that their actions on stealing our freedoms on behalf of COVID are justified. This balancing task, as the court recently stated in U.S. versus Controni, should not be approached in a mechanistic fashion. For as was there said, while the rights guaranteed by the Charter must be given priority in the equation, the underlying values must be sensitively weighed in a particular context against other values of a free and democratic society sought to be promoted by the legislature. Now, of course, they're talking about the honorable values of government to benefit society. They're not talking about the values of the men and women. If the values of the men and women mattered to the government, we would have the opportunity to vote on the issues that affect us. Balancing test. Justice Dickinson underlined that both in articulating the standard of proof and in describing the criteria comprising the proportionality requirement, the court has been careful to avoid rigid and inflexible standards. They're citing more case law, but once again, judges have a lot of discretion. The proportionality requirement. It becomes necessary to assess whether the measures adopted are appropriate and proportional to the objectives sought. And in R versus Regina versus Edwards Brooks and Art Limited has set out a three-step approach that must ordinarily be taken in the following passage. Second, the means chosen to attain those objectives must be proportional or appropriate to the ends. The governments they're speaking of. If a government is going to infringe on a charter right, applying the Oakes test or the proportionality test, their means chosen to attain their objectives must be proportional or appropriate to the ends. The proportionality requirement, in turn, normally has three aspects. The limiting measures must be carefully designed or rationally connected to the objective. they must impair the right as little as possible, and their effects must not so severely trench on an individual or group rights that the legislative objective, albeit important, is nevertheless outweighed by the abridgment of rights. So once again, this is exactly part of Rocco Galati's suit. Rationality. The next question then is whether the policies of mandatory retirement are rationally connected to the objectives sought. And of course, they're referring to this case, but the rationality test is, are these policies rationally connected to the objectives sought? And once again, I believe, although I haven't read the entire case file, I believe all of this is part of Rocco Galati's case. Minimal impairment. In assessing proportionality, and particularly the issue whether there has been a minimal impairment to a constitutionally guaranteed right, it must be remembered that we are concerned here with measures that attempt to strike a balance between claims of legitimate but competing social values. And once again, ladies and gentlemen, whose social values are judges and the courts upholding? The people of Canada or the government of Canada? Thus, in matching means to ends and asking whether rights or freedoms are impaired as little as possible, a legislature meditating between the claims of competing groups will be forced to strike a balance without the benefit of absolute certainty concerning how the balance is best struck. And having a right impaired as little as possible? Really? Don't you find that pathetic? You either infringe on a right or you do not infringe on a right. You don't infringe as little as possible. Does that sound like a constitution to you? If the courts say, well, we apply this test, and if it's reasonable and they're infringing on a right as little as possible, we'll let it slide. Nice, huh? Does that sound like a fair and just system? Court is called upon to assess competing social science evidence respecting the appropriate means for addressing the problems of children's advertising. So there was another case where this was discussed. The question is whether the government had a reasonable basis on evidence tendered that banning advertising aimed directly at children impaired freedom of expression as little as possible, given the government's pressing and substantial objective, which they claimed was to protect the children, but allow the corporations to still target innocent children in their advertising, to infringe as little as possible for the benefit of everyone. Doesn't that sound reassuring and lovely to you? Again, the proportionality test, the objective of the legislation being sufficient to warrant overriding a constitutional right. as per Section 33 of the Charter of Rights and Freedoms, which, to paraphrase, says, notwithstanding or despite anything in Section 2, your fundamental rights, or Section 7 through 15, your legal rights, despite what it says in your fundamental freedoms, despite what it says under your legal rights, the government can take it away. And one of those things they use to determine whether it was a breach or not is all of these tests. Proportionality. So yeah, was it more important than infringing on a right? It remains to consider whether the means employed to achieve them are proportional in terms of the guidelines previously enunciated by this court and set forth earlier in these reasons. First of the matters to be considered is whether these means are rationally connected to objectives. The rationality test. I find little difficulty in holding that the legislation is rationally connected to the objectives. And I shall only briefly deal with this issue since most of the same considerations arise in discussing whether the legislation impinges on the guaranteed right as little as possible. Moving along. Justice Gray observed, consideration of the propriety of the legislature's methods cannot be divorced from the knowledge that the legislature's cautious conduct is motivated by the concern for an orderly transition of values. Good grief, ladies and gentlemen. And again, more on minimal impairment. And moving right along. Decisions on such matters must inevitably be the product of a mix of conjecture, fragmentary knowledge, general experience and knowledge of the needs, aspirations, and resources of society and their components. They are decisions of a kind where those engaged in the political and legislative activities of Canadian democracy have evident advantages over members of the judicial branch. Well, of course they have advantages. Members of the judicial branch are appointed. This does not absolve the judiciary of its constitutional obligation to scrutinize legislative action to ensure reasonable compliance with the constitutional standards. And once again, there's good judges and bad judges, but they're all part of the same system. And it's not a system of justice because it's based on deliberate deception, fraud, and trespass. I do not mean to suggest that this court should, as a general rule, defer to legislative judgments when those judgments trench upon rights considered fundamental in a free and democratic society. Quite contrary, I would have thought the Charter established the opposite regime. And some judges honestly may not know about the whole history of the BNA, what they call the Constitution Act 1867, because Pierre Trudeau changed the name from the BNA Act 1867 to the Constitution Act to perpetuate the illusion that we have a constitution in Canada. So some judges truly believe in this. And like I've said before, they take the BNA as law. They disregard anything that's brought up about the BNA. For example, the enacting clause being repealed by the Statute Law Revision Act of 1893, about Section 2 being removed by the Statute Law Revision Act. One must, in the present context, recognize that if the legislative goal is to be achieved, it will inevitably be achieved to the detriment of some. Moreover, attempts to protect the rights of one group will also inevitably impose burdens on the rights of other groups, which we can see is happening now. They're taking away rights, the freedom of speech, in order to protect the rights of those who find some speech offensive, who are protected by these same rights already, and who also have tort. If actual harm is done, then the person doing the harm can be held liable. And they're saying there is no perfect scenario which all the rights of all can be equally protected. And once again, I disagree. The common law, the law of do no harm, that protects everyone's rights. If you've done harm by infringing on another person's rights, or a corporation infringes on your rights, you can hold them liable. It's a tort. It's a harm. And common law deals with just that. And in court decisions and opinions, they state that yes, tort, common law, tort is the answer. And I will show you that in upcoming videos. I know this has been super long, ladies and gentlemen, but nothing worthwhile comes without time and effort. So please bear with me. We're almost done. I'm not going to go through this whole case. I've gotten through most of what I wanted to show you. The smoking gun evidence, if you will. The subordinate authority to which the legislative powers are delegated must be subject to the same obligations and constraints as the enabling authority. If it were otherwise, Parliament and the legislatures could avoid their constitutional obligations simply by confiding to others the authority to exercise their powers. Wow! Now, doesn't that sound like the powers granted under the Public Health Act in Alberta? They're avoiding constitutional issues because they have conferred powers under the guise of COVID. Powers that destroy the Constitution. And those will be cases going to court as well. So yeah, that's exactly what's going on. In many provinces, in many states, in many countries, this medical authority can do anything they want under this legislation because it's a public health emergency. This means that all regulation-making authority conferred on cabinet, individual ministers, civil servants, commissions, or administrative tribunals must be exercised so as to comply with the Charter. It means still more, however. Not only must the regulations themselves comply with the Charter, but the actions taken under the authority of those regulations also must comply. So, more legal opinion, ladies and gentlemen. And see, I told you this was jam-packed, full of information. How we're part of the government. That they've just discussed that it's for the government to confer special powers on someone or an entity in order to bypass the Charter. Well, it's not us. It's the medical health officer. It seems to me, therefore, that the control test has something valuable to say at a general level. Once again, here's another test that they apply when trying to decide if an entity is part of the government. One can, of course, conceive of entities that are subject to government regulation and that are therefore subject to control, but that are in no sense part of the government. McDonald's, for example. They have to abide by governmental occupational health and safety regulations, food regulations, all of that kind of stuff. But they're not part of the government. Private corporations that are subject to government regulation, once again, just like any corporation. The evidence that one is dealing with government action will, of course, be even stronger if one can point to a direct nexus between the government and the activity in question. Taxes. Government responsibility. So we're taught and led to believe. Then we are filing taxes. We are paying taxes, which is traditionally a government activity, the collection of taxes. We have to submit our taxes. And how about when we are collecting GST on behalf of the government? That is absolutely acting as an agent of the government. The government has authorized me through statutory authority to charge you GST, which I have to submit to the government. And are they paying us for being agents of the government? One can argue through the services they provide that we're paid. That is our compensation. One could argue that when we get a pension, when we retire, Canada Pension Plan, after 65, that is compensation for our work for the government. I would argue that it's not. The evidence that one is dealing with government action will be stronger if you can point to the nexus between government and the activity in question. But it is the same function for which they are incorporated that gives them the status, and not the mere fact that they are incorporated and have their authority to act bestowed upon them by their incorporating statute. Emphasis added. And so we're incorporated. We just saw in the Interpretation Act applying our maxim of statutory construction and interpretation that the inclusion of one is the exclusion of all others. And it says right there in black and white, person is a corporation. Because they have no jurisdiction over men and women. The government entity test. A third approach might center on the question whether a given body is a government entity. This approach focuses on the question whether an entity performs a task pursuant to statutory authority. So, your driver's license, for example, the Highway Traffic Act. If the entity performs a task using the highways, driving, pursuant to statutory authority through the Highway Traffic Act and regulations, we're authorized to drive on roads and highways by the government. If you do not have a license authorized by the government, it is stated you're not authorized to drive on the roads, and therefore you're breaking the law. This approach focuses on the question whether an entity performs a task pursuant to statutory authority or whether it performs a task on behalf of the government in furtherance of a government purpose. Like I said, income tax, GST, rules of civil procedure. When a Crown agent acts within the scope of the public purposes, it is statutorily empowered to pursue. It is entitled to Crown immunity from the operation of statutes because it is acting on behalf of the Crown. Well, it doesn't tell us, the men and women, that when we're acting as a Crown agent, that we're statutorily empowered to pursue, that we're entitled to Crown immunity from the operation of statutes because we're acting on behalf of the Crown. Do they tell you that? Well, I could argue that yes, they do. And they tell us that in the Criminal Code of Canada, I believe, if memory serves correctly, it's section 15. Anyway, the section is called Disobedience to De facto Law. Bam! So they subjectively choose. Well, men and women are acting as agents of the Crown, but we're not going to tell them that when they're acting as agents of the Crown, they have immunity from the operation of statutes, which is laws in Canada. Which doesn't that explain how Justin Trudeau does whatever he wants? All governments of Canada, provincial or federal, do whatever they want with no repercussions, or they might get a $500 fine. There you have it. When a Crown agent acts within the scope of the public purposes it is statutorily empowered to pursue, it is entitled to Crown immunity from the operations of statutes because it is acting on behalf of the Crown. Well, the Prime Minister was created by statute, just like the artificial person is created by statute. However, we're not afforded the exact same immunity that they are. Does that sound like a legal, lawful, fair, just system to you? I don't think so. Sorry for getting excited, people, but this stuff just makes me crazy. and Professor Hogg in Constitutional Law of Canada, second edition. Also, clearly included are those crown corporations and public agencies that are outside the formal departmental structure, but which by virtue of the ministerial control or express statutory stipulation are deemed to be agents of the crown. And furthermore, further opinion, I would favor an approach that asks the following questions about entities that are not self-evidently part of the legislative, executive, or administrative branches of government. They consider the judiciary as part of the administrative branch of government. Does the legislative, executive, or administrative branch of government exercise general control over the entity in question? Once again, we've reviewed this. Ask these questions regarding the artificial person that we're deceived into believing is us. And consider that we applied for the birth certificate and then we applied for the social insurance number because we were told they were mandatory. Does the government exercise general control over that entity in question? We can't drive cars. We can't get married. We can't go fishing. We can't get a bank account. Almost every aspect of our life is now controlled by the government. Number 2, does the entity perform a traditional governmental function or a function which in more modern times is recognized as a responsibility of the state? Once again, ladies and gentlemen, taxes. Has that not been recognized as a responsibility of government? Is the entity one that acts pursuant to statutory authority specifically granted to it to enable it to further an objective that the government seeks to promote in the broader public interest? Once again, GST. Through statutory authority, we collect GST on behalf of the government. Then we submit it to the government, which is a government objective, collecting taxes, which they claim is in the broader public interest. But we know they just do whatever they want with our tax dollars, send them overseas, enrich themselves, so on and so forth. But once again, if we apply those 3 questions recognized in law to the artificial person and then the agent of the government, our social insurance number, our government employee ID number, there's no question that we're part of the government. Each of these questions is meant to identify aspects of government in its contemporary context. An affirmative answer to one or more of these questions would, to my mind, be a strong indicator that one is dealing with an entity that forms part of government. And he says, once again, an affirmative answer to one or more of those questions can only be an indicator, and the party is always open to explain why they're not part of the government. So that's pretty big for anyone out there challenging or defending themselves in court. This is pretty important information. And there's even more. The questions I have listed are intended only as practical guidelines to those trying to decide whether a body that is not self-evidently part of the legislative, executive, or administrative branches of government may nonetheless be part of the government for purposes of 32. And again, the control test. How much control does the government have over that entity? The government function test. I'm not going to go any further. I think I've gotten the point across. But once again, as I always do, I will leave the link and encourage all of you to do your own research, develop your own level of knowledge and understanding, and then pay it forward. Show someone else. And it's been my experience as an adult educator, and in this day and age, myself personally, people can tell me a lot of things. I've been told a lot of things by a lot of people. But unfortunately, I have to prove things to myself now before I believe them, which I encourage you to do as well. Don't believe what I'm saying, but believe what I'm showing you. Because it's not me saying this, this is me showing you through their own Acts, statutes, regulations, codes, bylaws, yada blah 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 blah. I know legalese is terrible, but when you start putting the pieces of the puzzle together, the final pieces, through their own legal opinions and decisions, it becomes magical and exciting. That being said, stay tuned. There is more case law discussing how we are acting, unbeknownst to us, as agents of the government. Thank you for watching, ladies and gentlemen. If you enjoy the content, please like and share.